Hello, everyone, and good day, and welcome to another time on PUL 341. Today we are on to topic 7, and we shall be looking at some issues in criminal law. Remember, we've looked at other topics under this criminal law 1, and today we are going on to corporate criminal responsibility. Now, talking about corporate criminal responsibility, what do we have in mind? Normally, we know that corporations or companies are juristic persons or the artificial persons. They are normally recognized as having personality that is capable of enjoying rights and also being subject to some duties or to some liabilities. Now, under the common law, companies are responsible for crimes subject to certain exceptions, such as murder, robbery, rape, and other kinds of offense that might be created statutorily. It was also virtually impossible for a company to incur criminal liability, especially when the offense requires mens rea. However, with the passage of time, criminal English criminal law came to recognize corporate criminal liability against company even for offenses requiring mens rea. So we have section 5 subsection 1 of the penal code defines a person to include a company or a corporation, as the case may be. It is worthy, however, that very few offences impose term of imprisonment as the maximum punishment for offences, and it has been a difficult problem to fix intention or menstrual or mental state requirement of offences committed by companies. However, as persons, though they are seen as juristic persons or artificial persons, the court have come to say that the problem of fixing the will or mental state of an artificial person, which a company has been looked into, and the court have said that a company may, in many ways, be likened to a human being that has a brain, a nerve center, which controls what it does. It also says that it has hands which hold the tools and acts in accordance with directions from the center. Some of the people in the company are mere servants and agents and cannot be said to represent the mind or will. Others are directors and managers who represent the act directing mind and will of the company and control what it does. The state of mind of these managers to be cannot be said to be the act of the company. This was the position of the court in the case of Bosney Engineering Company and Graham and Sons Limited, an old case for that matter. This case has been followed in many cases that have to do with the mens rea or has to do with the mental state of a company. Also, the case of Tesco Supermarket Limited and Nastra is also quite instrumental. Now, from the views of the court, from academic opinions, and from even juristic opinion, it has become clear that mens rea or state of mind is no longer an impediment to corporate criminal liability. In other words, whether it's a corporate person, an artificial person, mens rea can still be imputed. So, cases like Eastern Region and Amalgamated Press Limited, the court have stated inter alia that uh, um, a corporation can have knowledge of the falsity or of the wise of what is published in a newspaper. In other words, the corporation can become liable, can have the mens rea, can have the necessary intent to of the falsity or the wise of the publication in a newspaper. Also, the case of Mandela's and Carabiners Limited, the case of Carabiners and Mandela's and IGP is also very instructive. Now, after solving the problem of mens rea, the only obstacle that might appear to be that of that might appear to also be for coming for a corporate criminal liability, for a corporate liability, is imposing a commensurate punishment, especially where only imprisonment is provided for. So, is it possible to impose punishment on a company, to send a company to prison, and things like that? The court has stated that a corporation cannot be charged with an offense, the only punishment of which is imprisonment. So, in other words, when there's an offense and the only punishment is imprisonment without option of fine, then it will be difficult to charge the corporation. So, the practice is for court to impose fines in lieu of imprisonment, even in cases where the court would have imposed imprisonment as a deterrent. So, what we're saying here is that it is now possible to impose mens rea on corporation. Also, corporate bodies are limited to the kind of offenses you can punish them for. You cannot bring offense of rape, offenses of murder against corporate bodies. Again, initially, corporate bodies cannot be imprisoned or whatever, but in the absence of imprisonment, it is always possible to impose fines on corporate bodies. So, in short, corporate bodies can incur criminal liability and can be responsible for offenses committed by the company through the either through the directors or through other agents acting on behalf of the company. So, having said that, we'll briefly look at other forms of liability. We've looked at corporate criminal liability. Let us look at strict liability offenses. What do we mean by strict liability? Strict liability is a legal responsibility for injury, even if the person found liable was not at fault or negligent. In strict liability offenses, the requirement of mens rea is normally negative in exceptional circumstances may be provided by statute. However, while some acts produce outcomes that are criminalized regardless of the state of mind of the defendant for the safety, protection, and of the public. In other words, strict liability offenses are normally offenses that that actually arise from regulatory legislation, and normally they are normally being imposed in order to protect the public, for the safety and protection of the public. It is an offense that is normally seen contrary to criminal liability because the criminal liability normally look at the blameworthiness of the persons or of the accused person. In strict liability offense, they necessarily don't have to be that blameworthiness for the person or for the whoever to be liable strictly. So, like I've said, strict liability offense arises in regulatory legislation that controls such matters as traffic offenses, sale of goods, selling alcohol to minors, statutory rape. In the case of Adekoya and the state, the court stated that while the mens rea is an essential ingredient in every offense, the presumption can be deduced from the can be deduced. So, what are the advantages of strict liability? Protection of the public as it serves as a deterrent. Again, like I said, for the safety, basically for the safety and protection of the public. So even though you are not blameworthy, whatever you are producing, in as long as the public that will use it, whatever you are doing, even as much as the public that will suffer from the dangers of such a thing, you will be punished strictly for such offenses, though there's no blameworthiness on your part. So it's basically to serve as deterrent to others, to be more safety conscious, to be more protective of the public in the production or in the use of whatever services they are rendering. It also serves to regulate activities that can present danger to public health, safety, or morals. It is easier to enforce as there's no need for guilty mind. You don't need to prove the mens rea or whatever. The act has been done. Whether the person is guilty or not, the law says it's strictly liable. So it saves time as people are likely to plead guilty. Because it's a strict liability offense, there's really no, the law doesn't require your guilt or not. So it normally saves time, and then sentencing likely to be lesser for lack of blameworthiness. Again, it encourages compliance with the law because you know that if you don't take due care, whatever you are doing, if you are not safety conscious, if you don't comply with the provisions of the law, you could be punished for that particular act that you are doing. So you have to be very careful. Disadvantages are again, apart from the disadvantage that it imposes liability on people without fault. This has been said it's one of the main disadvantages in a strict liability offense. How can you say one is guilty of an offense that he never intended? So Imposition of strict liability is contrary to the principle of criminal responsibilities, just like what we have just said now. Again, it does not give way for fair hearing, hence, it can be unjust and unfair. Strict liability offenses carry social stigma, because you've been punished for that particular offense. Everybody looks at you as if you were actually guilty, of the offense, as if you actually went out of your way to commit the offense. It has not been proven to improve standards. This is another fact about strict liability, in the sense that those that have, the essence is to serve as a deterrent to others so that they don't fall into the same boat. But has it been able to deter others? Has it been able to improve the standard of things, of doing things? Not much can be said. Not much can be said here, because not much really has been done, or not the standard has not been improved greatly by imposition of strict liability offenses. Again, we look at vicarious liability. So, talking about vicarious liability under the criminal law, the essence is to assign guilt or criminal responsibility to a person for wrongful act committed by someone else. Let me say someone else in his care, someone else working under him, someone else taking instructions from him, someone else working under authority from him. So in the Nigerian case of Sharon Paint and Chemical Limited and Ezenwa, the court held that vicarious liability is an indirect legal responsibility, such as the liability of an employer for the act of an employee, or a principal for tort of agent. It is the master that must be responsible for the actions of the servant. It cannot be otherwise, since the law does not operate inversely. So this is very, very clear. Normally, you cannot see an employer becoming liable for the works of an employee. It is always the employee becoming the employer. I mean, you cannot see an employee becoming liable for the fault of the employer. It is always the employer becoming liable for the faults of the employee. So, what are the basis, or what are the justification for vicarious liability? The justification is based on the ground of policy consideration and social insurance, in the sense that it enables the victim to see it enables um, the victim to sue the most probable person in order to ensure compensation. In other words, if the victim would not definitely not sue the employee, he would rather sue the employer that he knows that he will be able to get compensation from. So the essence there is to ensure that you get something, from from a bigger person that the employee was working under. So vicarious liability is usually rationalized based on respondent superior. That is, let the superior answer, like what we said, the employer and employee. And qui facit par alum facit per se. That is, he who does a thing through another does it himself. So in all of this, we have seen where the Supreme Court have held in the case of Ifeanyi Chukwu and Sole Bonnem that to succeed in a claim for vicarious liability, the prosecution or the plaintiff must establish the existence of three elements. That is, that the wrongdoer is liable for the tort, that the wrongdoer is the servant of the employer, that the wrongdoer acted in the course of employment. So there are some things that we must look for here. The person you are charging for, you must be sure that he was the one that committed the offense. Yes. Two, that he also committed the offense working under somebody, under the employment of his my master, that he committed that offense while he was working. He was not on a frolic of his own, but while he was working under the master of his employer. So the relationship could be between parent and child, employer and employee, servant and masters. Again, on vicarious liability, a corporation under the law is held criminally responsible with respect to non-feasance, which later included misfeasance acts. Again, a juristic person can also be liable vicariously for all offenses with such exceptions as assault, murder, murder, rape, and perjury. If you look at most of these offenses, they are normally offenses against the person. So, however, for other forms of offenses, the corporation can be criminally liable. So let's just take a quick look at some of the questions we'll have for this under this note or under these discussions we've just had. Now that there's thin line that's a little difference between strict liability offenses and vicarious liability offenses we are told to discuss. For you to do this, you must understand what strict liability offenses are and what vicarious liability offenses are. Are there any differences? What are their differences? And then you'll be able to state it. Then two, that a corporation is liable for its acts and omissions. Discuss with the aid of relevant authoritating the exceptions, if any. Of course, we agree that a corporation can be liable for acts and omissions, and that because mens rea of the guilty mind will be imputed, but at the same time that there are exceptions to the kind of offenses that it can be liable for, which we have also discussed which we have also talked on. So we will end our topic for our discussions for today, and we'll meet next time to discuss more on other forms of offenses. Thank you for your time. Goodbye.